Thank you for your rating. Thank you very much for joining us today. We now would like to start the webinar, The Climate Crisis and the Role of Judiciary, featuring former Hawaii Supreme Court Justice Wilson and other experts on recent climate litigations in the United States and India. I shall serve as today's moderator. I'm Taura with Kiko Network. First of all, on behalf of the organizer, I would like to invite Professor Takeshi Shimamura to give us the greetings. Over to you.
皆様こんにちは。
Good afternoon, everyone.
ウェビナー、気候危機と司法の役割の開催にあたりご挨拶申し上げます。
Allow me to extend the word of greetings. I would like to extend my greeting on the occasions of the webinar Climate Crisis and the Role of the Judiciary. My name is Shimamura, and I am engaged in education and research of environmental law at the Graduate School of Law of Kyoto University. This seminar is being held jointly by Climate Network, the Center of Interdisciplinary Studies of Law and Policy Research Unit of the Environment and Law at Kyoto University Graduate School of Law. In March, we held a seminar on climate litigations in 3 East Asian countries, South Korea, Taiwan, and Japan. The agenda for today's seminar includes discussions of climate litigations in the US and judiciary in India. We are delighted to announce that we will be joined by speakers from Hawaii and India. Welcome to Kyoto from far away. Thank you very much indeed. We are also pleased to welcome Professor Osaka from Tokyo. Thank you very much indeed for joining us today. Today's seminar will be divided into 2 parts. In the first part, Professor Eri Osaka from Toyo University and Judge Michael Wilson, former judge of the Hawaii Supreme Court, will report on the climate litigations in the US and Hawaii. Additionally,
日本の名古屋で昨年8月に提訴された若者気候訴訟などについて浅岡美恵弁護士から手短に紹介をしていただきます。第1部のモデレーターは日本の気候訴訟において主導的な役割を果たしてこられた浅岡美恵弁護士が務めます。浅岡先生は気候ネットワークの理事長でもあります。第2部ではインドからお二人の報告者をお迎えいたしました。まずジンダルグローバルユニバーシティの副学長であるクマール先生からクマール教授からインドにおけるエココンスティテューショナリズムについてご報告をいただきます。次に国会議員であるとともにインド最高裁判所の上級弁護士でもあるシンビー博士から SDGs を達成するためのインドの法律政策についてご報告いただきます。第2部のモデレーターは日本および世界の気候訴訟を研究している京都大学の市原雅子助教が務めます。最後に時間が許す限り質疑応答の時間を設けたいと思います。それでは報告者の皆様どうぞよろしくお願いいたします。
はい、島村先生どうもありがとうございました。今日はオンラインで配信をしておりまして、Zoom の音声の切り替え機能を使いまして、日本語と英語でお聞きくださるようお願いします。ご質問は Q&A にお書きいただければ、後で回答させていただくようにいたします。今日は京都大学および気候ネットワークの主催、そしてインドのジングルグローバル大学の協力のもとに開催をさせていただきます。6時半終了の予定ですので、最後までよろしくお願いいたします。では、最初第1部、浅岡さんの方にお渡ししますので、よろしくお願いします。
皆様、お待たせいたしました。
Thank you very much for waiting.
第1部を
Now we would like to start the first part. I'm going to serve as the moderator for this section, and my name is Asaoka. And as has been introduced already, the retired Justice Wilson.
のお話をよりよく私たちが
In
理
order
解で
to
きますように
digest the presentation, before that, I would like to invite Professor Osaka and to talk about some of the representative litigation and cases
影響がさまざまなところへ出て
The
おり
United
ますけれ
States
ど
being
も、その
influenced by the Trump
実情など
administration.
もそこか
So
ら
I
伺
hope
われ
that
る
she
の
will
で
be
はない
able
か
to
と思います。
update
では
us
まず大阪
on
先生よろし
the
くお願いい
most
たしま
recent
す。
situation. Over and to Professor Osaka.
はい、はい、大阪でございます。
This is
本日
Osaka
は貴重な
speaking.
機会をいただき、
I
ありが
thank you
とうご
for
ざい
giving
ま
me
す。
this valuable
本ウェ
opportunity
ビナー
in
の主
today.
催協力して
We
い
would
ただいた
like
方
and to
々、と
thank
り
the
わけ浅
organizers
岡
and
美玲先
supporters
生、
of this
島村
webinar,
哲先
especially
生、
Professor
石
Mie
原正先
Asaoka
生にお礼
and
申し上げ
Professor
ます。
Masako
では
Ichihara.
私がお話しする内
What
容
I'm going
は、
to talk
ウィル
about
ソン
is
裁判
something
官
that will
の基
serve
調
as a
講演に向けた
briefing
ブリーフィング
note
として
for
お
the
考えいた
keynote
だければと
speech
思
to
い
be
ます。
given by the retired Justice Wilson.
ではもう一回、はい。はい、失礼いたしました。はい。
I'm
こ
sorry.
ちらが気候訴訟の件数のグ
Here's
ラフ
our
です。
chart
ア
describing
メ
the
リカ
number
で
of
は以上ケー
climate
スのものは元々
litigations.
の元になっているデータ
The
ベースが
figures
すでに
for the
反映さ
past
れない
few
ため、
years may not be
ここ数
accurate
年の
because
推移
of
がちょっと疑問
litigations
を感じ
outside
る
the
ところ
US
でござい
aren't
ますが、
immediately
2000
reflected in the
年代
database
以
on
降
which the
ア
chart
メ
is
リカで
based,
もそして
so we
ア
can
メリカ
see,
以外でも
but at
確
least
認さ
we
れる
can
こと
see
がある
that
と
there
思い
has
ま
been
す。
an increase since the 2000s.
そのうちでもアメリカが件数においても突
Then
出
why
してお
is
り
the
ます
United
が、
States
それは
so
なぜでしょう
salient
か。
in the number of climate
私として
litigations?
は2つ
I
理由が
think
ある
there
な
are
と
two
考えており
reasons.
ます。それらを説明する前に、
But
気候
before I
訴
explain
訟には
about them,
気
it's
候対
important
策
to
を必要
note
とされるため
that
の訴訟と、
there are
暮
two
らしのた
types
めの
of
訴訟
climate
があるということに
litigations.
ご留意い
One
た
is
だけ
to
ればと
advance
思いま
climate
す。
actions, and the other to slow them down.
このように説明は省きますけれども、
So
さまざ
I
ま
will
な
not
気
go
候訴訟
into
が
the
あるというこ
details.
とで
There are
す。
different kinds of climate litigations.
それでは、次にですね、
Now,
先
next,
ほど2つ理由があるというふうに
I
私は
was
考
talking
えている
about
と
two
申し上げました
reasons
が、
in my
まず
view,
は1つ
so
目
I would
は
like to
アメリ
touch
カ
upon
司法
them.
の世論
First,
基盤が
regarding the
あるのではないかと
institutional
思っています。
foundation of the US justice system.
まずアメリカには、連
First,
邦と
the
50
United States
州
has
ワ
the
シントン
layers of
DC、さらに
different
は、準
jurisdictions,
州などで
including
す
the
ね、
federal
たくさん
government,
の法域、
50
ジュリスディク
states,
ションがあります。
Washington
日
DC,
本は
and the
一つなんですけれど
territories.
も、
Japan only one.
その各法域に、裁
And
判
each
所
of
と
these
いうかですね、三
jurisdictions
権がありまして、
has its
そして
own
方言も大
courts
変多様
and
です。
diverse sources of
さらに
law
人
and
的資
three
源という
branches
こ
as
とで、
well.
今
In terms
回
of the
ご紹
human
介することが多
resources,
くなると思いま
which
す。
I'm going
若
to
者
talk
訴訟
about
の、
at
ア
this
ワーチルドレントラ
session,
ストですね、支え
the
てきた、
for example,
ま
our
あ、公益
children's
法律事務
trust,
所がございます
which
し、他に
represent
も
the
たくさんの
young
NPO 法
plaintiffs,
律事務
and
所が
there
ご
are
ざいま
different
す。
kinds of
さ
law
らに若
firms
者と
as
いえ
well
ば
as
例え
NPOs.
ばロースクールの環境法クリニックとか
And
ですね、
then
そういった
the,
ところで
the
活躍する学
students
生
active
さんたち
in
も、そ
environmental
ういっ
law
た人的規制の
clinics
一部という
at
ふうになっており
school
ます。
laws, they also constitute
最
in
も
such
これらは
human
気候対
resources.
策を
But
行動す
that
る
can be
気
also
候対
true
策を起こらせるような
for
訴訟で
groups
すね、
who try
邁
to
進するような
delay
方たちも多いという
climate
ことを意味します。
actions.
第2の、連邦の気候
And
政策におい
please
て、
take a
様々
look
な
at
理由になっていると
this
思いますが、
slide, which
こ
shows
ち
the
ら
federal
をご覧
government's
いただ
slow
きますとです
reaction
ね、
to climate
ちょ
changes.
っとその政権が変わることによって、
With the
かなり
changes
こう
of
進
the
んだり揺り戻しがあったりと
administration,
いう状
they are
態です。
supposed to be
今
slowed
の
down
政
and
権はマ
sometimes
サチューセッツと
progress.
EPA 可視化
For
最高
example,
裁
the
判決、
Obama
これは、
administration
気
trying to
候変
leverage
動
the
の一環は
Supreme
二酸
US
化炭
Court
素が
ruling
大気汚染物
in
質であるっていうね、
Massachusetts
有
and
名な判決ですけれど
EPA.
も、
This is a
こ
famous
の最高裁判
ruling.
決をてこに、連邦レベ
And
ルで気
then
候対
that,
策を進めようとしたのですが、
to push forward,
そ
use
の後
this
は、
to
この
push
ような
forward
状
with the
況に
climate
なっており
actions
ま
at the
して、
federal level.
バ
But the
イデ
current
ン政
situation
権
is
で
far
よ
from
うやく成立したインフレ抑
the
制法です
desired
ね、
picture.
これも今
For
や風
example,
の
that the
話というふ
Inflation
うになってお
Reduction
りま
Act
す。
that was formulated by the Biden
表の
administration
右
is
側が
almost
詳細
falling
結果は
apart.
連邦裁判所で出され
The
たものですけれども、
decisions listed on the
連
right side
邦
of
の
the table
最上
were
級裁
issued
判
by
所である
federal
合衆国
courts.
最高裁の現在の
And
構成は
then
どう
what
なってい
about
る
the
でしょう
current
か。
composition of the United States Supreme Court, the highest court at the federal level?
はい、簡
Well, simply put it, the composition is 6 conservatives and 3 liberals. Well, just because they are conservative, it doesn't necessarily mean they are indifferent to climate issues, but that the court opinion in West Virginia versus EPA, which I'm going to introduce in my presentation, but this, I should say, paints a bleak future. In the first place, there is no way to expect the current EPA to seriously tackle climate issues. But the problem is that even when administrations change, the influence of the administration that appointed the judges continues until they are replaced because they have lifetime tenures. The cases contested in state courts based on state law are resolved at the state Supreme Court. But if the case is determined to involve federal law, it is transferred to the federal court. Therefore, how the federal courts will deal with the climate issue is very important. Now, I would like to briefly introduce each of the climate cases that we expected to be mentioned in Justice Wilson's keynote speech. As I explained the objective of my presentation, the briefing on Justice Wilson's keynote speech. First, with West Virginia versus EP. It is not that simple. As a matter of fact, this started under the Obama administration. The Obama administration attempted to enact a federal law to combat climate change in parallel with the EPA's greenhouse gas emission restrictions. However, unfortunately, the administration failed in these efforts. Therefore, the Congress was reluctant to take actions. Therefore, the government in October 2015, the EPA promulgated the Clean Power Plan, or CPP, which restricted greenhouse gas emissions from existing fossil fuel power plants, but its implementation was halted by the U.S. Supreme Court. Under the Trump administration, the EPA issued a rule that repealed the CPP and slowed climate change action, or rather, rules were made, but they were only instrumental in slowing down climate change actions. And however, on January 19th in 2021, the United States Court of Appeals for the D.C. Circuit overturned the rule. In response to this, some states opposed to the CPP. That means those states who are reluctant to take climate actions filed a petition for certiorari with the United States Supreme Court. And on June 30, 2022, a court opinion written by U.S. Supreme Court Chief Justice Roberts applied the major questions and doctrine, so-called major questions and doctrine by its name, for the very first time. And if I may backtrack. This major questions and doctrine holds that when an executive branch regulates decisions of economic and political importance, Congress must clearly state that the authority is granted into an agency. The court opinion held that Congress did not give the EPA the authority to compel states to adopt the so-called generation shifting practice as defined in CPP. So the EPA's efforts were aborted. However, I neglected to explain about this in the right bottom. Justice Kagan strongly criticized this opinion. EPA, instead of the EPA, the Supreme Court made its own decision. In that way, Justice Kagan made a very severe criticism of the court opinion. So I think Justice Wilson is going to talk about this on this topic, and I would like to move on to the next topic. That's about the youth cases. The first one is Giuliano versus U.S. Many of you know about this, but allow me to recap a little. On August, in 2015, a long time ago, 21 young Americans filed a lawsuit in the United States District Court for the District of Oregon, suing the United States. The plaintiffs ask for demanded relief, in particular, to declare that their constitutional and public trust rights have been violated by climate change caused by the federal government's actions or inactions, to enjoin further violations of their rights, and order the federal government to prepare and implement an enforceable nationwide remediation plan to phase out fossil fuel emissions and reduce excess carbon dioxide in the atmosphere. This concept of top public trust doctrine may not be familiar to the Japanese population. One firm across the United States was involved in these cases, and their argument is as follows: that under the public trust, the government should hold natural resources in trust for the benefit of its citizens. And if the air is considered as a trust property, then the legal structure would allow citizens to become plaintiffs and sue the government, demanding that it fulfill its fiduciary duties if the government neglects to take measures against climate change. However, there are the Alec L. versus Jackson. It was supposed to be within the domain of the state. That's what the argument went. So there was such an argument based on the public trust doctrine, but that the litigants switched to the importance of the human rights violations. I will not go into all the details. And against this argument, as you can see, that Judge Aiken of the United States District Court denied motions to dismiss filed by the federal government, the American Petroleum Institute, and other interveners.
And the appellate court in 2020 said that it lacks the standing of the plaintiff and remanded the case back to the district court. And there are three requirements of the standing. The climate restoration plan. There is damage caused by the climate change, and also there is a causality. However, retroactability, what is argued by the plaintiff, regulators will not be able to supervise it. Therefore, it should be left up to the politicians as well as to the Congress. That is the ruling. But out of the three judges, one judge dissented. Such remedy can be remedied. This is Brown versus Board of Education was conscious of that particular case. Therefore, the remedy was accepted. However, it was 2-1. And after the remand, the parties engaged in the settled negotiation led by Judge Aiken. They engaged in the settlement negotiations, but that ended up in failure. We thought that the case would end, at least I thought so. However, in 2023, Judge Aiken allowed the plaintiff to amend their complaint to seek declaratory judgment that the federal government has violated the plaintiff's constitutional rights and to proceed to trial. I earlier mentioned about the possible issues of the redress. Therefore, Judge Aiken has came up with. Therefore, he agreed to proceed to the trial. And Hill versus Montana case gave an impact to this. However, the federal government, there has been some changes to the government, but they made many petitions to hold the case, and they have taken some move here as well. In May of the last year, in Oregon, United States, mandated the implementations of the 2000 rules. However, that was denied, and that was the end of this particular case. I need to brush. Next is Held versus Montana. Ms. Asaoka, I'm sure will talk about this because she would like to make a comparison of Japan's youth climate litigation. Montana's constitution is fairly unique. There are many regulations pertaining to the human rights. That's why they have intentionally picked the state of Montana, and they brought the case to the court. And this is at the district court in Montana. And remand was also accepted. That was a ruling. Now, the state of Montana have a court of two instances, but it went up to the Supreme Court and maintained the original ruling. This is wonderful. The constitutions of Montana. The District Court of Montana. Back in 70, there has been the amendment of the constitutions and included this new provisions. And the Congressperson was there as a witness on behalf of the plaintiff. So that was a great support. Thank you very much. I'm sorry, I am speaking so fast, and this is very important one because this is about the case in Hawaii ruling related to Justice Wilson. This is also the youth litigation. The state of Hawaii, why it was selected? Because due to the Constitution, there is this very important provision included. So if you can read through what is written here. So the case was brought to the court. However, in the end, it ended up in settlement. The plaintiff, environmental right in Hawaii, or the public trust doctrine was what the plaintiff argued. Of course, obtaining a favorable ruling is important. However, because it ended up in settlement, therefore, very wide-ranging remedy was made possible. And in order to steadily implement on the settlement, the court will have the supervisions until 2024. 2024 is a very important year because that is the year to achieve the carbon neutrality or the introductions of more of the renewable energy. So the supervisions of the court will continue until 2045. And I shouldn't be talking about this. I should defer to Justice Wilson to talk about this, but this is a very important case. So that's why I'm taking this up. This is the Hawaii Supreme Court ruling in 2023. This was a very long case. In 2023, in March, at the Hawaii Supreme Court, HELCO's biomass power generations agreement was not accepted and unanimously come up with this ruling, which was in itself very good. However, let me talk about the Judge Wilson's comment. Now, first of all, the biomass emission. This is a fundamental right to life-sustaining climate system judged by the Public Utilities Commission. And also due process was being emphasized by Judge Wilson in the constitutions of Hawaii. There is a due process provisions. And also, please focus on the final two lines. So there has to be effective countermeasures, or else rule of law cannot be exercised. So very important supplementary comment was written by Justice Wilson, and this is under Trump administration. When I talk about the relationship of the federal court and Juliana cases in many of the different states, there is a tort cases related to climate or the greenwash, climate washing, violating the right of the consumer is being brought to court. And the state of Hawaii in May of this year brought the case to the court. And the current administration learned about the cases and tried to stop. And these are some of the cases that the government has brought to the case. The current federal government have this particular stand. That's why I wanted to share this. Well, sorry, I have to omit many of my pages, but this concludes my briefing. But please listen more to the details in the keynote speech by the Justice Wilson. I'm looking forward to his report. Thank you very much. This concludes my report.
ありがとうございました。
Thank you very much.
多分ロースクールの授業でもなかなかに
I think this is something that we can listen to in the law school classes. There are many litigations in the United States, and from different viewpoints, there were a lot of discussions. Columbia University officials mentioned that, the officials sent me reports 2 or 3 times a month, but it is difficult for me to catch up on the trend. It is somewhat difficult for us to understand the overall picture of the U.S. litigations, and under these circumstances, and we have the representatives from Jindal University and retired Justice Michael Wilson to make a visit to Japan. It is a rare opportunity, and we will be able to seize on this opportunity to learn about the situation. And this was crystallized into this seminar. And Michael Wilson is such a passionate person who has the greatest concern about the future of the earth or the climate and change, and his devotion to the cause. I think you can see that in the presentation material entitled Lessons from Recent Climate Lawsuits in the United States and India, Implications in Japan. And I think it is going to be an important theme and for us. And then I think you also have the related materials, reference materials. I hope that he is going to use them in his presentation. And over to Michael.
I would like to say how grateful I am to the interpreters to try to make my words coherent. I'll thank you ahead of time. And I'll try to speak a bit slowly. I have been given 45 minutes, but I'm going to try to keep this to about 35 minutes so people will have an opportunity to ask questions. Well, one way to describe what I'm about to present is that this is a time of incredible importance to the human race with respect to the application of the rule of law. I do have a bit of an echo. Do you know it's echoing what I say? Okay, fine. What does this mean in terms of our lives when I say that we are at one of the most important points in human history, and in many ways it depends on the rule of law? And this is why I was so excited to come here today. And this is why, the importance of this issue is why I'm happy to work with anybody who is involved in this issue that's here today. Please don't hesitate to follow up. The challenge is a fundamental challenge that society often calls a human right. We're just checking. Oh, did you want to start the slides? Okay. You don't need to start the slides until I say start the slides. Yeah. I don't want people to just be distracted necessarily by the slides. So let me go back to these words that are generally interesting words in the area of legal analysis, human rights. I think we all can say the usual experience with this term, a human right. The public, when they hear that, may be affected by it at a level that is very personal. Maybe it would be fair to say that there are more and more people becoming aware of this idea of a human right as a result of a scientific phenomenon that's taking place. But everybody in this room thinks about a human right in a way that probably translate into the damages that are now becoming extremely famous, extremely historic in the area of climate litigation. What am I talking about in terms of damages? Climate anxiety. So many young people and professionals that deal with this human right to a life-sustaining climate feel it. They suffer for it. In the classes that I teach, I have a whole room filled with students who do have climate anxiety, but they also have a feeling of institutional betrayal. In other words, they've given up believing in their institutions that are supposed to protect them. The reason we are here today and the focus of my presentation, therefore, addresses this phenomenon that's taking place in society, a phenomenon in which the executive branches of government and the legislative branches of government have provided fuel or a reason for young people to be very suspicious and maybe have climate anxiety. But there's another branch of government that I think has become much more of a focus for hope and courage. So the two words I'd like to use to describe this presentation are hope and courage. We can prevail. It's very important for this issue to be seen in a way that is, from a legal point of view, straightforward, simple, easily addressed. So that will also be a theme, not just that young people should have hope and courage with the application of the rule of law, but it's really straightforward. Let me give an analogy in terms of a straightforward example of a violation of human rights that's quite famous in the United States and probably in Japan. It's now being used as something of an analogy to the violation of the fundamental right to a life-sustaining climate. This is the Korematsu case. Korematsu case is a case in which all the Japanese people in the United States were incarcerated during World War II. Well, this has become a straightforward, simple analysis in which it's recognized that it was a violation of the law for the Supreme Court to justify this incarceration. The Constitution obviously does not allow discrimination based on race, especially where there was no proof that the Japanese community as a whole was a threat internally in the United States. So this part of my presentation is meant to be a bit of a summary about what's coming. So let's speak about what I mean in terms of this being simple, in terms of an application of the rule of law. And you can see it in the decision of the court that I had the privilege to be part of, in which the court said, the right to a life-sustaining climate is obviously a fundamental right upon which all other rights depend. That was the theme. It has become the theme in other cases. So let's start with this hopeful, important theme, understanding that this is simple. The most important case probably so far that's been decided with respect to the right to a life-sustaining climate is the case of the Ranjin Singh Great Bustard case decided by the Supreme Court of India last year, in which the court found there's a right to a life-sustaining climate. It's obvious when you read their opinion because it pertains to the right to life. So you can't have a life-threatening climate system if you're going to recognize the right to life under the law. Simple. Another simple analysis that you can see in the materials and you're probably familiar with is a decision in the South Korean Supreme Court case decided approximately a year ago, following the same type of analysis that was pursued by the Supreme Court of India. And there, once again, the court made the decision that the right to be protected from government policies that can lead to the destruction of the climate system are inconsistent with their constitution and the statutory framework. Simple. Most countries have a statutory framework that prevents the government from poisoning the atmosphere. Sometimes it's formed in, it's in a statute. Then there's common law that stands for the same principle under the public trust doctrine. But the supercharged law that empowers men and women to make a profound decision to protect an entire country and to some extent the planet, of course, is the highest and most powerful system of laws, which are the constitutions. It's so exciting, in a way, that we have this group of men and women who have embraced their duty to apply the law. But let's not give it more confusion than it was confusing in the Korematsu case to say that you can't violate the right to be treated equally by incarcerating all the Japanese people. This constituency that's at issue is much bigger than an ethnic group, like a Japanese community. As you know, our Supreme Court also found, I think you probably know this, but our Supreme Court found that slavery is constitutional. That's at the beginning of our country. Again, this is a straightforward political decision, often called an atrocity decision, that perpetrates a fundamental violation of human rights. But my point is, think about the constituency. The community of Black people in the United States is not as big as the community that's at issue in the right to a life-sustaining climate. As you know, in the United States, our Supreme Court also found that it was constitutional to discriminate against women and not allow them to have the right to vote. Another atrocity that was corrected. But that constituency is not as big as a constituency that Ari Osaka from the Kiko group, Masako Ichihara from the Kiko group, or Professor Osaka, your analysis, I can tell, means that you also understand this violation of a human right affects a constituency that nobody really discriminates against in practice. Young people. Of course, they're innocent. It's not their fault. But what's happening to them in the context of this litigation is regularly called the greatest intergenerational injustice in history. So, getting back to litigation, getting back to the work that I know that you are fully committed to. It's not that complicated. It's simple. I think in the not too distant future, the decision of the United States Supreme Court majority in West Virginia versus EPA will be seen as an atrocity decision by more than the constituency of judges and lawyers that understand that there is a right to a life-sustaining climate. So that's a theme. I could go over other cases that express that theme, that give hope. But let's speak now in the minutes I have left about strategy. Because we want to prevail in this issue for reasons that are certainly not academic. But at this point, it's important to recognize that to be able to prevail, we have to be honest. And if we're honest, we understand this is the greatest challenge lawyers can address at this time, and maybe ever, since, as the Secretary General of the United Nations says, we are now, and he said this about 24 months ago, we are now on the road to climate hell with our foot on the accelerator. So telling the truth means that we can't say everything will work out if we just let things move in the direction that they are. And that's why litigation has ensued. And who's bringing those cases? When you speak about strategy, it's so heartening to think who brings the cases. And I'm so excited to be here because you represent that community that has the courage to bring the cases. But the cases are being brought by children. The cases are being brought by children. The cases are being brought by the most sympathetic community on earth. And the dynamics show that they're being brought with the support of their mothers. You think about strategy, think about mothers. In the materials that I have, the slides that I have, there are slides of mothers that are organizing internationally to support their children. Also think about female judges. You know, Ann Akins, the famous judge in the Juliana case that decided there's a right to a life-sustaining climate. Because that's a good strategy that worked out to some extent in Juliana, certainly worked out in the sense that when the case was brought, it was brought before Ann Aiken, a mother of, 5 children. Josephine Staten, that wrote The Dissent when the case was reversed, is in that category. But, picking your jurisdiction and understanding your judges makes a difference. And Kathy Neely, the judge that wrote the case for the Montana court, this is the case in Montana that followed our Hawaii cases. It was an actual trial where young people testified, along with scientists that testified as mental health professionals about the trauma to the young plaintiffs from being part of a climate system that's started to devastate their lives. She's another example. So strategically, it's good to start with the point that this is not difficult. The severity of the emergency is known to everybody in this room, but in speaking about strategy, let's ask the question, why is the executive branch not acting to protect the children? Why isn't the legislative branch? And really, who's responsible? Because it allows us to have hope. The actors in this are such a small group. In the materials, you'll see that the International Energy Agency pointed out that the most successful corporate group, political scientists are calling it a governance group, not necessarily just a corporation because of its influence globally, just the 4 or 5 major oil companies. The profits from 2022 were 29 billion for the biggest, Exxon. The next year it went to over 50. Now that bespeaks incredible power. But if you add to that during that period, the subsidies of the top 5 or 6 oil companies was $4 trillion. It's very breathtaking. It's hard to really understand this. That's why it is important to have some opportunity for law students to learn about this, to learn about what is going on. Why would this simple violation of the law not be something that's acted upon by government? Unfortunately, law schools don't teach this. Now, I'm fortunate to be teaching at Jindal Law School, and I've been able to teach at University of Hawaii. But as you know, this is not a class for law students. They don't hear about climate law. However, when you do learn about it, it gives you a strategic insight. $124 million was spent just on lobbyists by the energy companies in 1 year, 2022. And the combined income of the 4 main oil companies was greater than the economic output of either Switzerland or Colombia or South Africa. So this is an extremely successful community of businesses And they have been successful in increasing greenhouse gas emissions. As you know, since the Paris Agreement, the idea of reducing greenhouse gas emissions so that we only have 350 parts per million in the atmosphere has not been operative. That's not what's happened. Strategically, what does this mean? We had time, it would naturally prevail. It is such an extraordinary violation of corporate duty, of tort duty, of constitutional duty. Eventually, like the cigarette cases, you remember in the cigarette cases, the idea was whether smoking caused cancer. And the tobacco companies were able to use a stable of prostitute experts or experts that were good at not telling the truth to say that tobacco didn't really cause cancer. But eventually juries found them liable and things changed. And now in Hawaii, for example, although there was great objection from the tobacco companies initially, you can't smoke in a bar, can't smoke in public places. So I think there's certainly a natural tendency for the truth to prevail. And except in the United States, you can't find that many politicians or even judges that are willing to accept the proposition that we don't have a climate problem. In fact, as you can probably see from the cases, the case analysis, courts don't have that refuge. Self-respecting judges that have some self-respect take the approach that I think has been taken to some extent here in Japan, but certainly its best example is in the United States, the approach that we do have a problem. We do have a climate emergency, but that's not for judges to decide. And so, getting back to strategy, these kind of false narratives of judges that say that there is an emergency, but the courts don't have the ability to make a decision with respect to remedies that would be workable, is not going to prevail much longer. Of course, that decision, as I think we all know, that analysis that it's non-justiciable, the idea of litigating a violation of the law with respect to creating a poisonous atmosphere as a result of carbon emissions, that particular point of view is now basically being rejected by courts. It's rejected by the Supreme Court of India. Of course, citizens have standing to bring the claims, and it's been rejected, as you can see recently, by South Korea. It was rejected as long ago as 2015 by the Supreme Court of Pakistan, by the great Judge Mansour Ali Shah in the Laghari case. So that kind of fatuous, unconvincing analysis of the majority of the United States Supreme Court and the two judges, federal judges in the Juliana case that reversed Ann Aiken, I think is going to fade eventually, and it won't be there. So that gets me to a fundamental part of strategy. And I'm always interested to hear from you on strategy, but a fundamental part of the strategy that has to do with sui generis emergency of the Supreme Court of India in March of this year used the term existential to describe the threat to climate. In the Redeema Pandey case, why is it existential. Why do we say sui generis, an emergency beyond all other emergencies that have been addressed under the law? Time. How much time do we have before we hit the tipping points? That is the reason why this is such an extraordinary emergency. And of course, it's a reason why I think courts have been now willing to participate in this issue, and they're beginning to move forward with remedies. But when you consider that strategy, it means that it validates telling the truth in court, which judges usually are uncomfortable about. So maybe you could write this down for your own understanding about how complicated it is for judges to make this dangerous analysis that the court shouldn't be allowed to help the young people that bring these cases. Maybe if you look at the oral argument in the Juliana case, I had all my law clerks watch this. It's very profound because you get a chance to see the striking lack of responsibility, the violation of the legal duty of the judges, the two judges who reversed Ann Aiken. People tend to think of Juliana as a case where the young people lost. I think you could say in a way they won. Two judges agreed with the plaintiffs, right? Ann Aiken and Josephine Staten. And two judges disagreed. Two judges that disagreed gave an analysis that backfired. So we're able now to talk about the kind of power politics and decisions of the courts. An example of just how much authority private interests have, influence that they have on judges to make decisions, atrocity law decisions. And it's also reflected in West Virginia versus EPA. And in terms of the reason we're talking about this, it has to do with strategy. To not give too much importance to those cases and understand that eventually the significance of that kind of jurisprudential thinking will be seen in the context, very likely, of atrocity law. But we're still left with the emergency. So I'll conclude with two examples of strategy that could provide for some profound hope. Hope profound in the sense that maybe the transformational change that's called for by the United Nations. In my materials, I referred to the report of the United Nations in 2023, where it determined whether the Sustainable Development Goals were being met, particularly with respect to Sustainable Development Goal 13. They said that, they pointed out that each year has gotten hotter. Carbon emissions have continued to grow rather than be reduced as called for in 2015. And in fact, if we do want to be successful in time, it means we have to reduce greenhouse gas emissions by 40% by the year 2030. 60 months. Okay, so getting back to these two examples of hope and how things can work. You have a cadre of young lawyers, and this room is a classic example of young lawyers and a community that supports them with courage, that are trying to get to the golden tipping point, which is a tipping point where it becomes comfortable politically to take the transformational change that's necessary and reduce greenhouse gas emissions sufficiently. And their story is something that just makes me so excited every day, and makes me feel so privileged to address you, because Julia Olson, we probably all know who Julia Olson is. She's a mother. She wanted to protect her children, so she created our Children's Trust, and now she is the most successful lawyer on this issue in history. And she's only been around with her law firm for maybe 10 years. It's a similar story to the one that my brother in the Avatar of Justice in India has, who created the best law school in India in just 10 years. You can do it. We can do it. And she did it to protect her children and the children in this community. Sejong Yun, this name's probably familiar to you. That's part of the reason I came here. Sejong decided his country, South Korea, even though it's an industrialized country like Japan, where you would think the Supreme Court would be on the side of big industry, he believed in those justices, and he believed in the truth of it. Plus, he knew he had to do something. And lo and behold, he wins. It worked. But he did some very important strategic thinking. You know, he had a conference with the Supreme Court of South Korea to bring in the information. Another example of hope is just the community of young people in Hawaii. And this is a model that it would be great to be able to spread around so that the young people with institutional betrayal concerns or with a sense of climate anxiety can see the golden tipping point in a way. Because what happened in Hawaii, after we established the right to a life-sustaining climate, Julia Olson came forward. She filed a lawsuit on behalf of young people against the state Department of Transportation and prevailed. But the way that she prevailed, she had a whole stable of fantastic experts, including the experts that would testify about the trauma that the young people were experiencing. But her powerful experts and her sincerity and this Governor Josh Green, settled the case. Thank you. I have 5 minutes left. All right. Josh Green stepped forward and said, of course, we need to protect the right to a life-sustaining climate, and entered into a settlement agreement in which the court maintained jurisdiction for 10 years. And the young people have been incorporated in the planning process to come up with a plan, climate protection plan. So there's hope. And that kind of a model could happen potentially in Japan. You know better than I do whether your judges would be positioned to finally recognize this right and allow young people to bring the right. But strategically, don't give up. And strategically, you'll prevail eventually. I can't imagine that, you know, those of you that might get on the court, you know, it's unfortunate sometimes if you have a court that's there for life, but there will be a rotation. So in conclusion, every single time you have the opportunity to express to your colleagues and particularly young people that there's a chance for hope, I hope you consider our network. I hope you consider our community. It's a small community, but it's incredibly powerful. And I want to help you to prevail. And I anticipate, because of what's happening in the United States, where the brazen violation of their duty by federal judges and the brazen violation of environmental laws by the President of the United States, like the Juliana case, could mean a backlash. It'll only last for so long, perpetrating a false idea that there isn't a climate problem. And more, the academic community is gathering together. If there was some way to provide law schools with funding on this issue, so you don't just have outliers like Jindal Law School, just outliers that are teaching it, that could make a big difference too. But we're getting there. We're gaining momentum. So I do want to thank you again. Miyai, thank you so much. And Masako, it's been so wonderful working with you, at least over the internet. And Professor Osaka, it's been so great sitting next to you and hearing your summary. And thank you all for coming today. It's inspiring to just be in your presence. Aloha.
はい、ありがとうございました。
Thank you.
日本で裁判官であられた方からこういうお話を聞く
I
こ
think
とができるというのは
it is a
極め
great
て
honor,
稀
at the same time
であ
quite
りまして、
rare,
そうし
to
た今
directly
今日お
listen
話し
to
いた
the
だいたような
speeches
思い
given
で、
by
そのハワイ
justice
の
in the United
発電
States.
所、バイオマス発電所の事件なども
And there
担
was,
当され
he
て、
was in
さらに
charge
追加的な
of the
意
case that
見も出され
involved
て
the
いかれ
biomass
てきた。
power
本当に
station.
長い年月
And
こうい
he
う思
was
い
also
で裁判所
committed
の
to
裁判
other
官の役割は何かと
cases.
責任は何かと
That means
考えて
he
こられ
was
たこ
elaborating
とが
on the
直
role
接
of the
お
justice
話
and
としてお
judges.
聞きできて
I
とて
think
も
it was
ありがたいと思い
a
ます。
good
日
experience
本で
for us
そうい
and
う
to
時
have
代が早
direct
く気候変動についても訪れ
the
てもらいた
talk
いものだと思い
with
ます
them.
が、
We are
ちょっと
hoping
外の
that
ワ
the
ークを受けて、
situation
は
is
い、
going to
で、
turn
残念
to
な
the
がら
better
日
in
本の実
Japan.
情はなかなか
Well,
に厳しいも
however,
のであります。
despite
こ
that,
う
the
したらいいですか？
situation in
どこで
Japan
出る？
is relatively harsh.
こちらこれでいいですか？はい、はい、まず、皆様からの質問
First
に
of
対
all,
し、質問も今来ておりますの
I
で、
think we are expecting
そのお
to
話を
receive
お
questions
聞きした
on
い
the
と思うのですけど、
presentations, and we are
若干
going
短い
to
時間で日
entertain them
本
later
の
on.
気候変動に関す
So
る
please give me
裁
a
判
short period of
つまり
time
裁判所
to
の
give
状
an
況を
explanation
お話し
about
し
the
ておき
current
たいと
status
思いま
of
す。
the youth
ま
climate
た
cases in
日
Japan.
本の聴衆の皆様にも今どんな状況にあるのかと
And it
い
is a
うこ
good
とを
occasion
アメ
to
リ
give
カ
you an
や、
update
これからお話しいた
on
だ
the
くイン
Japanese
ドと日本
situation.
と対比
And
しな
then
が
by
ら考
doing
えていた
so,
だけ
you
る
will be
と
able
いいの
to
ではないかと思いま
compare
す。
the
日本
situations
につきま
with
しては、
those
お
in
き
the
まして
United
は、
States and
こ
India.
の
In
数年の
Japan,
間に石
for the
炭
past
火
several
力発電
years,
所がたくさ
the
ん新
thermal
設をされ
power
ましたというこ
stations
とが
have
あります。
been
で
built
そうし
one
た
after
新
another.
しく今から石炭火力発
So
電所を
those
作っ
thermal
ていくことは
power
とんでも
stations
ないとあまりにも時代
are
錯誤であ
now
るということで地
built
域の住民
one
の
after
方が訴
another
訟を起こし
at
て
this
きました。5つほどあ
late
りますが、いずれ
stage,
もも
and there
う
was
終結
such
を
an
しており
opposition
ます。
against them. And then there were some lawsuits
動きますか？
that were brought
動
up,
かない。
and they
いけました
all
か？
came to an
で、
end.
行政訴訟と民事訴訟とがございました。
There are two
行政
different
訴
types,
訟と
the
いうのは、
administrative
環
litigations
境
and civil
影響評価
litigations.
手続きの可視を持って、
The
審決
administrative
を取り
litigation
消され
is
たいという
relating
そういう訴
to
訟
the
でありますが、
administrative
これは
procedure,
全くその入り口にも入れず、
and
原告
that
適
the
格スタンディングが
that
否
the
定をされたと
plaintiff's
いう
standing
ことでありま
was
す。そ
denied.
の理
So
由という
it
のは
was rejected
気
at the
候
very
変動の
beginning.
影響を受
And the
け
reason
ない
behind this
我々個人
is
の
that the
権利利
individuals'
益を認めた
interests
法律がないからあなた方には権
are
利はないと、
not
こういう
identified in
こ
specific
とであり
laws
まし
and
た。そして
acts.
気候
That's the
変動
reason.
問題は一
And
般
then
的な公
the
益的な
climate
問題と
change
して
issue
政治や
should
政策
be
の中で
regarded
解決
as
さ
the
れ
general
るべきもの
public
だと。
interest
これが
issue and should
最
be
高裁
pursued
判所、日本
through
の
the
最高
policy
裁判
as a
所
whole.
もこの考え方
And
を
this view
オーソライ
is
ズしている
also
と認めているというの
authorized
が今の
by
現
the
状でありま
Supreme
す。
Court.
で
And
もう
this is
一
the
つ
current
神戸につ
situation.
いては民事訴訟
And
が
then
起こされ
with
て
in
きて、
Kobe, the civil
も
litigation,
う
it was
7、
brought
8
up.
年も継続しておりましたが、
The
先
6
般
7
終
years
結終了いたしま ました。
continued, but recently it came to an end.
原告の救済を求め
And
る
in this
権利は
process,
ないと。
the
そ
plaintiff
れはなぜか
rights
というと、気候
were
変動による
denied.
原
The
告らの
reason
影響
behind
は
this
抽象的なも
is
ので、
that
人
the
格的
impact
な
was
利
abstract
益
and the
とはまあ言
cannot be
えないと
considered as a personal
いうよ
interest.
うなもの。これはジュリアナ事件に関するアメリカの最高裁判所で
The
もこんなこと
US
は言わなか
Supreme
った
Court
という点では
even didn't
本当に日本は
mention this
権
kind
利
of
性をお
thing.
よそ認められていないと
Therefore,
いう
the
ことであり
Japanese
ます。さ
courts
らに
uh,
被告らの
do
排出
not
行為と
respect the personal
我々市民が
interests
受ける気
and
候
the
変動の
rights
影響との因果
and
関
the
係は極
impact,
めて複雑
the
で
causal
希
relationship
薄と
between the defendant's
そし
emissions
て
and
被
harm
告
is
たち
complex
電
and
力事業
weak.
者には
That's
石炭
their
火力
another
の発電事
that's
業や
another
整理
comment
system
of
や
theirs.
の責任という観点では電力を
And
ど
with
う調
regard to
達
the
するかという
defendant's
のは政治の問
liability,
題だと
the means
民
of
主
power
的なプロ
procurement
セ
should
ス
be
で
considered
政治の
from a
中で解
policy
決されると裁判
perspective,
所の
and this problem should be
役割
solved
ではな
within
いと、
the
そんなことになったわけであります。
political
で、
level,
日本では
and that
温
is
暖
not
化
supposed to be the
問
role
題、気
to
候
be
変動問
played
題につい
by the
て
court
海外で行われているような国に対する訴訟、あるいはいわゆる枠組み訴訟
against
という
the
訴訟
nation,
は起こされ
against
た
the
ことが
government
ありません。
or the
そ
framework
れはなぜかと
litigation.
いうと、
There we
極
didn't
め
have
て法律が個
them
人の権
of
利
that type
をそういう訴訟が可能となるような
because
実態法
the
や
legal
手続き
framework,
が
in
ないという
particular, the
最初もない
substantive
と、
law
こういうこと
is
になって
lacking.
います。憲法自身に環境権の規定はないの
And
ですけ
then
れ
there
ど
is
も、
no
環
clause
境権の
relating
規
to
定
the
はなくて
environmental right
も、
stipulated
イ
in
ン
the
ドの先
Constitution.
般の最高
However,
裁判
that
所の判
said,
決にもあり
that
ます
as
ように、
they
その気候
defined
変動で影響を
by
受けない権利
the
というのは、
the Indian
インドの
Supreme
憲法に
Court
おいても平等権とか自由権
that
から
the
導かれ
right
ると、
of
これは日
freedom,
本にもあ
the
るわ
right
け
of
ですので、
equality,
本当は
that
な
can
な
be
るはずなんで
evoked
すけど、
in
まあ
their
権
court
利がないと。
decision. So
そして、環境基
similarly,
本法をはじめ、
Japan can also
日
talk
本には
about
気候
this.
変動に関する
Therefore, in
国が
Japan,
排出
we
削減
do
をどの
not
ようにするのかっていう数値目標の入ったような
have
削減を国に義務付けた法律もな
no
いと。まあ、全て
obligation
が
or the
政策
law
課題に
that
なっていて、
that
もう言え
stipulates
ば
the
きりがない
government
ほど日本には
to
市民
introduce
の
specific
権利がない。
numerical
参
targets.
加の
In
プロ
this
セス
way,
も
such
極め
rights
て
are
法的な
very
保障が
limited,
なく、
and there is
NGO
no
に訴訟
legally
を起こす
backed
権利も認
right
められ
of
ていない
civil
と。まあ、これほど
civilian
何も権利のない
participation,
国は
citizens
世界中日
participation.
本が最
So looking
ト
around
ップではないか
the
と。まあ、
world
そんな状況に
jurisdictions,
あります。
I
まあ、そ
think
れで
Japan
枠組み
is
訴訟は起こせなかったわ
one
け
of the
であります。
countries
で、
where
石炭
those
火力
legal
発電
rights
所も、
were not
はい、
sufficient.
すでにの裁判ももう終了してきたんです。
And
終わって、
those
それ
lawsuits
自身は終わ
came
ったん
to
で
an
すけれ
end.
ども、昨年の8月、
But last
日
August,
本のここの地図にありますような
as you
北海
can
道から
see
九
across
州まで
Japan
の
from Hokkaido to
14歳
Kyushu
から
Island,
29歳までの
the
16人の若
plaintiffs
者が
aged
原
between
告となっ
14 and
て、日
29
本の主要な電力会社、火力
brought
発電会
a
社、10社
lawsuit
に対しまし
against
て、
10 major Japanese
価
thermal
格が
power
求める
companies.
1.5度に、気温上昇を抑
And
え
the
ていく
claim
ために
was
必要とさ
and
れ
to
る
introduce
水準での
necessary
排出
measures
削減を
for
義務と
reduction of
すると、
CO2
それ以
so
上超えて
that
排出しては
the
ならない
temperature
という
rise
ことを
could
求める
stay
民事
within
訴訟を
below
提起いたしました。
1.5
この訴
degrees
訟は、
centigrade.
ジュリアナ事
And
件な
this
どで、あるいはモン
litigation
タナの
was
ケースなど
inspired
で、
the
あるいは
Montana
ハワ
case
イ
and
の
Juliana
事件な
case
ど、
or the
若者
Hawaii
たちが
case
声を上げている
in
と、まあ、
which
ドイツでも
the
そうですし、多く
young
の国でそういう動き
people
が見られておりま
were
す。
taking
この若者
actions
たち
not
の
only in those
被害を
jurisdictions
最
but
も
also,
受
for
けて、
example, in Germany. Young people are
そ
the
して
ones who
今、
are most
政
exposed
策
to the
決定
threats
に
of
参加で
global
きない、
warming,
そうした
and
子
they
ど
are
もた
also
ちの
deprived of
権
their
利
right to
を彼ら
participate
じゃ認める
in
べ
the
きだと、こう
politics.
いう訴
And
訟
their
で
rights should be
を起こし
recognized
たわ
by
けで
the
ありま
court.
す。
And
そう
that
した
is the
海外
reason
の
behind
訴訟
their
が非常に有意義を
they
築
are
けるもの
I think these actions also quite
電
encouraging.
力事業者が被告になっているという
And
のは、
then the power
オランダ
companies
で、
they are
オランダの
defendants
NGO がシェル
in
に対して提
in
起していた訴
the
訟、あるいは
Netherlands
各
in
いくつ
in
か
Netherlands
企
there
業
was a
に対して
litigation against
削減を
Shell.
求める訴
There
訟
are
を起こしてお
also
ります
other
が、こう
litigations
した
around the
訴訟
world
の動きなどを、
suing
我々も日本の
the
中で同
the
じ
power
問題だと、
companies.
この問
I
題
think
は
similar
世界
to
共
those
通の問題
actions
であると。 そ
in
して
Japan, we are
先
having
ほ
these
どウィルソ
actions,
ン裁
and
判
the
官が
world
強調
that
されましたよ
faces
うに、
that we
本当
face
に
is
気候
common
エマージェン
across
シー
the
である
world.
と、残された時
It is
間が
the
限り少ないと、
climate emergency. That means
もう
the
取り返し
time
のつかない
is
問題
limited,
に至るところに
and
直
we
面してい
are
ると。
now
もう
facing
今やらな
at
きゃ
the
ダメな
tipping
んだと
point.
いう
That
声を
means
反映させようと
it
した
is
もの
the
であり
time
ます。
right
若
now
者が
for us
被
to
害を受ける
take
ということはもうよ
actions.
く笑われていること
And
ですが、
everybody
で求め
knows
てい
the
る
global
削
warming
減の
is
水
going
準
to
っていうの
threaten
は、
the life of young
皆
people.
様よくご存
And
知の
what
通
we
り
are
の
aspiring after
IPCC の
is,
最
as you can
新
see,
の科
according
学
to
が
the
示してい
IPCC
る世界
scientific
全体で
document,
の
on a
1.5 度に
global
抑える
scale,
ための
the temperature
0.5 度
should
を大き
remain
く
below
上回ることは
1.5
なく、
degrees.
限られたオーバーシュートはあったとしても、そこに
And
抑え
then
ながら
even if
1.5 度
there
に
is going to
気温
be
上昇を抑えていくための
going over
世界全体
1.5
での
degree,
排出
but
削
there should
減
be
の
a
水準、
limited
この水
overshoot.
準での削
And
減
this
を求めて
range
いる訴
should
訟であり
be
ます。これは世界の
pursued.
平均といえば平均、世
This
界
is
全体
going
であ
to
ります
be
が、
the
日本
world
は応分
average.
の負担として、
And
また
then in
日
order
本
to
の
achieve
中の
this,
電
Japan
力火
should
力
take
発
up
電事業
the
者は
appropriate
さらにもっ
responsibility.
と大
And
き
in
な
particular,
早く
the
大き
Japanese
く
and
削
power
減するこ
companies
とが
and
求
should
められ
take
る。
the
私
leadership
アセアの
and
観
to
点から言い
accelerate
ますと、
their
そのはず
efforts
ですけれ
to
ども、裁
lower
判所
the
には少
emissions.
なくとも
At
この
least
水準
in
での
this
削
context,
減は義務付
that
け
the
るべきだ
courts
と、そうい
should
う訴訟
favor
を起こしている
this
もので
kind
あります。
of
で、被
approach.
告ら
And
の
for
実
that to be
写はここに
accepted,
掲げているような
that
ものでありますが、そうした目
these
標から
people
は
are
本当
taking
に届いて、目標も
actions.
なかったり、目標が届いてい
However,
な
when
か
it
ったり、
comes to
生産
those
数字が
private sector
不十分だと。
operators,
で、
they don't
僕
have
ら
a
が
specific
ね、
numerical targets or
努力され
insufficient
たりする
numerical
ところです
targets.
ね。そして日本のエネルギー期限の CO2 の排出
And
量の
then
約
they
4割
about
が火力発電
40%
事業
of
から出
Japan's
され
energy
ています。
derived
日
CO2
本の
emissions come
排
from
出
the
量
thermal
の
power
約3
stations
割
in Japan.
を超える
About
ものが
30,
この被
over
告ら10社から
30%
排出されてい
are
ると。
emitted
こうした大
by
量
those
発電事業
10
者であります。
defendant
だからあなた方は
power
減らす
companies.
必要があるんだと、
Therefore,
必要
they
があるんだ
are
と言っているんです
they
が、
should take
被告らがどの
responsibility
よう
to
に言っている
lower
かと言いま
their
すと、日本の
emissions,
電
reduce
力
their
事業者の
emissions.
主
What they
張
are
は、
arguing is that
原告ら
the
の被害は
plaintiff's
抽象的で、具体
argument
性がない、
is
切迫
abstract
性がない、現
and
実
lacks
性
a
がないと。
substance
そし
and
て、
lacks
科学
reality
も
and
政
urgency as
策も
well.
今後変わる可能性も
And
あ
the
りますよ
second
と。
argument
法的
goes
な義務は
science
な
and
いんですよ
international
と。
agreements
因果
may
関係も
change
曖昧で、
and
ま
there
と
is
いうよう
no
な
imposing
政
legal
治の世界で
obligation
解決する。で、政治
and
の世界は、ウィルソン裁
and
判官おっ
the
しゃいまし
issue
たよ
should
う
be
に、本当
solved
にそうし
through
た
the
方々
political
のロビー
process.
が働い
As
ていると、
Mr.
こう
Wilson
いうことなんだ
mentioned,
ろうと思
the
います。
political
はい。で、
arena
こういっ
is
た日本の
dominated
状
by
況を見てい
controlled
ますと、
by those defendant
希望
companies.
を
Given
持
that fact,
っていきたいと思うんですけれど、そして希望
we
を
are
持つため
hoping
に
that we can
戦
still
略が必要
maintain
だと、
hope.
裁判所
And
からの
then,
戦略という
as
のは誠に 裁判
the
官からの戦
Wilsons are
略をすると
mentioned,
いうのは本当
that
に
the strategy is
私たちは
important.
本当に
This is
ある意
going
味で
to
目を
be
覚ま
a
さないと
very
いけないところが
important
ありますが、
the
大
wake
変
up
勇気
call
づけられるもので
for
あります。
us and to
とても
know about the importance
こう
of a strategy.
本日実感をいたしましたのは、や
What
は
I
りこのい
strongly
かにイマージェ
what
ン
I
シ
have
ーというこ
strongly
とを
felt from the
社会全体で
presentations
理解する
is
か、
that
裁判官が
this
理解するかという
situation or if emergency and should be fully recognized by the population, including the judges, but that is not well understood by the people. So we have to think about ways, many things, and to overcome this situation. And that is the current situation in Japan. And I hope that there are going to be questions that will be answered.
There is a question raised from the person by the name of Aoki-san. And here in Japan, abnormally high temperature, torrential rain, downpour, typhoon, among others, the damage, harm is expanding. In the line of profession, well, he is a lecturer in the musical instrument. So this person seems to be in the music industry. So there are damages that we've seen in many places, inclusive of tornado damage. This abnormal climate is due to the climate change as well as the global warming, and it's accelerating, it's being expedited. Why courts, including Japanese court, will render the ruling to stop the people that uses large amount of fossil fuel energy, or let them discontinue? This is a question being raised. He has not identified to whom Aoki-san is addressing this. Professor Osaka? Well, first of all, can I hear your thought or observation? Now, to send a wake-up call to the Japanese judges, what will be necessary? I also would like to ask Justice Wilson to also comment. Thank you for the question. I cannot agree more. But as was shown in the final page of Ms. Asaoka, Professor Asaoka, from the defendants of the user of the utility, reading that kind of argument, and that is being accepted by the judge. Well, sorry, that is just an observation. I should not be spending so much time. Therefore, I would like to ask Justice Wilson and to make his comment. So, Justice Wilson.
Yes, Aoki-san, I thank you for the question. And of course, it's a question that's asked every single day around the world by young people. Why wouldn't a court allow young people to at least go into court to prove that the government is pursuing policies that is destroying their future by destroying a life-sustaining climate? And I think the straightforward answer has to be based, first of all, on science. So you're right. And that's been proven around the world. So that now the problem is judges who aren't following the law. And I think your question's a great one about how do you get the judges to follow the law? So there are really just two answers to that question. One is to make it clear to them that it's politically okay. So if you are talking about an energy company and you organize the mothers of the consumers of the customers that are paying the bills, and they create a political movement, that could make a big difference. In general, judges are concerned primarily about keeping their job. I mean, judges generally want to do the right thing, but the number one thing is to keep their job. And in the Supreme Court of Japan, it doesn't have to be a problem for the judges because they're appointed for life. So it's okay for them to make a decision that special powerful interests like the energy company or the capital investment companies that work with them, it wouldn't be that much of a threat to their job. So mothers and children make a big difference. to be able to support the young lawyers and the lawyers that are noble lawyers like Maie to come forward. And there's been a recent example of success. There was a judge in Thailand that ordered the prime minister to come up with a plan to protect the air and the environment, and the community organized to support him. And therefore, the Supreme Court supported this judge because it became politically correct. And I think this is inevitable. It won't be that much longer that the people that are given the privilege to serve as judges are going to be able to deny their duty to protect this fundamental right. And the point at which they're willing to do what most judges around the world are starting to do in other countries, the speed with which that change takes place will have a lot to do with you and other people that write letters or demonstrate or have conversations that make it clear that now the judges have to do their job. They can't come up with false analysis such as that there really isn't a problem that's posed to young people. It's not specific enough, or it's not dangerous enough. Again, this is not convincing, and it's something that undermines the credibility of judges to present facts that are false to support their analysis.
Thank you.
ウィルソン裁判官の
Justice
エッセイの
Wilson's
エッセイといいますか
essay
論述というべきでしょうか。お配りしている資料の中にも、
document,
裁判官は
I
今ま
think
で
in
の
it,
考え方
in this
そ
material,
して、
the
法の枠組み今ま
the
でやって
legal
きた裁
framework
判の
or
やり方
existing
の
legal
中で気
framework
候変動問題を扱っていくとい
will
う
not
こ
be
とは本
sufficient
当みんな難
for
しいと思うものだと思うだろうと。だけれ
dealing
ども
with climate change. That may be
この問
difficult
題は解決しな
going
ければなら
beyond
ない
the
と。
framework,
その
but
時
this
に
issue is
今あ
something
る
that
法
needs to be
はその
solved.
そ
The
の
existing
方向に
law
向
or
けて
legal framework
解釈
needs
を
to
し、
be
考え
reinterpreted
方も法律の幅も広げ、解
and
釈の幅も
legal
広げ、
scope of
この気候
interpretation
変動
should
問
be
題に
widened
ふさ
so
わしい
that
ような形を解
those
決をそのある
legal
法の中に、
frameworks
見出して、
are going
適
to
用
be
していける
sufficient
と。
to address
そして今ま
global
で
cha-
そうそうしてきた
global warming.
世界のいくつかの判例というのは
And some of
的
the
には
case
本当にそうい
law,
う
successful
考え
case
方で
laws were all based on that kind of
そうさ
approach.
せてきたというふうに思います。
And I
モンタナ
do
の裁
agree
判
to
は
this
私もト
view.
ライアルの場
The
面を
Montana
オ
case,
ンライ
in
ン
the
で見
case
る
of
ことができま
Montana
したので、
case,
本
I
当に
saw the
支持
scene
裁判官
online.
たった一人
So
の
the
小柄な裁判官が
single
必死で
just
判決を
judge
されたんだと。子供たち
wrote
の
seriously
心の中
a
の
ruling.
不安にも答えようとしてたみ
And
たいな、
then
ああ
I
いう裁
think
判官が
we
出て
definitely
きた。そして
need
モンタナの裁
such
判は
judges
三審、
more
ま
in
ずは
number.
三審制なんですけど、
And then
州
when it
の
comes to
政府と
Montana
原告との
case,
間でもう事
that
実
the
審理は終わってるから、二
the
審はど
fact-finding
して最高裁
instance
に特
it
別上
was
告しようみたいな、
over,
そんな合意が
and
で
then
きて、
skipping the
最高
next
早く判決、最高
instance,
裁の判
and
決
then
を
up
出
to
しても
the
らうこと
Supreme
が重
Court.
要だと。
I think it is
そんなことで
important
出たのが去
for
年
the
の暮れ
Supreme
の最
Court
高裁の判
to
決だ
come
ったと
into
いう話を聞き
a
ました
ruling at
と
the
いうような
earlier
ことで、
date.
まあ
So
そういう
that
裁判
well, that
所
was
に
actually happened last year.
やっていけ希望はあると。気候変動はどんど
I
ん進
think
む
there
し、
should be
残りの時
hope
間はどんどん短く
going
なるし、
forward.
目覚める裁判
The
官は
time
あ
is
ちこちで生
ticking,
まれてく
the
る世
watch
界
is
中、
ticking,
日本の裁判所
and
も
then
日本の社
I
会も
hope that
そういうふうに変わってい
Japanese
く
judiciary
はずだと
system
変
will
わっていくた
also
めの
change itself. And for that to be facilitated, we take actions as well. And thank you very much for very encouraging comments. I would like to take this opportunity to express my sincere gratitude. And Professor Osaka, thanks to you as well for your detailed explanation about the current situation in the US.
それではここで、
With this,
アメリカウィルソン裁判官を中心にしましたところは終了いたしまして、
we are going to
インドの話に移させていただきます。
this
はい、ではマイク
part
を田
one
原さんにお返し
on
いた
the
します。
United States and the microphone back into Kaura-san.
大変お待たせいたしました。ここからはですね、第2部として、インドからの
Thank you
報
for
告
your
という
patience
こ
and
とで、
waiting. Now
プレ
we
ゼン
now
テ
would
ー
like
ショ
to
ン
start
とい
the
うことに
part
なりま
2,
す。
the report from
ここか
India.
らの進行は、京都大学の市原さんにお
The
任せをいたします。
moderator
市原さん
is
よろしくお願いします。
Professor Ichihara from Kyoto University. Over to you.
皆様こんばんは。
Good afternoon, everyone.
皆様こんばんは。
Good
京都
afternoon,
大学大
everyone.
学院附属法政策共同センター環境と保有に
I am
特定助教の
Ichihara, Program Specific
ここ
Assistant
からはインドから
Professor
の報
at
告に関
Research
しまし
Unit
て
of the
3番
Environment
先生方に
and
説明
Law,
い
the
たし
Center
ま
of
す。まず
Interdisciplinary
はイン
Studies
ド
of
の
Law
エコ
and
力
Policy.
研究
We
機
will
環境
hear
圏思考積極
two
主義
reports from
及
India.
び
We
理
will
想社
first
会の
have
役割につい
Professor
て
Akuma,
ジンダルグローバル大学副学長で
Vice
教員の
Chancellor of Jindal Global
ラジクマラさん
University,
にお話
talk
しいた
about
だきます。ではラジクマラさんお願いいたします。
eco-constitutionalism in India. Over to you, Professor.
Thank you very much for this opportunity to be here at the Kyoto University School of Law. I'm personally very delighted to be here, especially to speak on a theme that I have been passionate about for long: eco-constitutionalism in India, environmental rights, judicial activism, and the role of civil society. For the last more than an hour, we have been hearing some fantastic perspectives surrounding environmental litigation, especially in the context of climate change, but not only limited to it. Justice Michael Wilson and the other speaker had covered with a stronger focus on US approaches to environmental litigation. What I thought I will do is to give you a tour de force on the evolution of environmental rights through the Constitution, through the courts in India. I will now try to keep it to the text because I'm conscious of the fact that there is simultaneous translation that is happening. Let me begin with Mahatma Gandhi, the father of our nation's prophetic observation, when he said, and I quote, "Earth provides enough to satisfy every man's needs, but not every man's greed." This insight lies at the heart of eco-constitutionalism, a vision where the protection of the environment is not just a legal obligation, but a constitutional imperative. India, though not originally born with explicit environmental rights in the Constitution, has become one of the world's most innovative environmental jurisdictions thanks to its judiciary, civil society, and constitutional imagination. This talk traces India's journey in transforming its legal landscape into a framework where environmental protection is a constitutional value, judicial activism is a safeguard, and civil society is a catalyst. First, the conceptual framework. What is eco-constitutionalism? Eco-constitutionalism refers to the embedding of environmental values, principles, and responsibilities within a constitutional framework. It means, first, treating nature and ecosystems as subjects of legal rights, not just resources. Second, viewing environmental degradation as a constitutional violation. Third, holding the state accountable as a trustee of natural resources. Fourth, recognizing intergenerational equity as a constitutional principle. It redefines the relationship between humans, the law, and the natural world, grounding sustainability within the broader goals of justice and democracy. Second, the constitutional framework from silence to stewardship. India's original constitution, which was adopted on 26 November 1949 and came into force on 26 January 1950, and we just celebrated the 75th anniversary of the adoption of the constitution, did not mention the word environment. But in 1976, the 42nd Amendment of the Constitution introduced two pivotal provisions. Article 48A, a directive principle stating that the state shall, and I quote, protect and improve the environment and safeguard forest and wildlife, unquote. And Article 51AG, a fundamental duty of every citizen, and I quote, to protect and improve the natural environment, unquote. While these provisions were not justiciable, they guided judicial interpretation. The Supreme Court of India began reading these duties in conjunction with Article 21 of the Constitution, which guarantees the right to life and personal liberty. Gradually, the court interpreted Article 21 to include the right to clean air, the right to safe drinking water, the right to live in a pollution-free environment, the right to ecological balance and biodiversity. Thus, the environment became a constitutional right through judicial innovation, not legislative drafting. 3. Jurisprudential framework, a judicial renaissance. First, the institution of public interest litigation. In the 1980s, courts in India relaxed the rules of locus standi. Any public-spirited citizen or non-governmental organization could approach the courts on behalf of the environment or affected communities. The Supreme Court of India even allowed letters and newspaper articles to be treated as petitions, what has been hence referred as epistolary jurisdiction. This opened the doors of justice to the voiceless, including rivers, forests, tribal communities, and future generations. Second, the expansion of Article 21. The courts interpreted life under Article 21 to mean a life of dignity, which naturally includes a clean and healthy environment. There are several important cases, including the case of Subhash Kumar versus state of Bihar in 1991 and Virender Gaur versus state of Haryana in 1995, affirmed these principles in a substantive manner. Third, doctrinal innovations. The judiciary developed distinctive doctrines that now form the backbone of Indian environmental law and jurisprudence. Some examples are the following. The public interest doctrine. M.C. Mehta versus Kamal Nath, a very important case in 1997. It was held that natural resources are held in trust by the state and cannot be privatized arbitrarily. The polluter pays principle. The Indian Council for Enviro-Legal Action in 1996, in that case it was held that polluters must compensate victims and pay for environmental restoration. The precautionary principles. Vellore Citizens Forum case in 1996. It was held that prevent environmental harm even in the absence of scientific certainty. 4. The principle of sustainable development. Narmada Bachao Andolan 2000, where it was held that development must balance current needs with ecological and generational sustainability. And the principle of absolute liability in the oleum gas leakage case in 1987, It was held that enterprises engaged in hazardous activities are fully liable for damage, and there is no exception. It was further expanded from the earlier case, which was an American case where in Rylands v. Fletcher, where it was held the principle of strict liability. The fourth aspect is quite unique to Indian jurisprudence and Indian Supreme Court. The creative aspect of what we call in India continuing mandamus. Courts kept critical cases open for ongoing supervision, especially in forest conservation, pollution control, and mining regulation. For example, the T.N. Godavarman case has remained active since 1995, which enabled the courts to constantly monitor and assess and evaluate and even orders different forms of responses to the ongoing situation. Fifth, judicial and civil society dialogue. Judges often appointed amicus curiae received affidavits from non-governmental organizations and relied on scientific experts. This created a hybrid model of participatory constitutionalism. In fact, one of our speakers today, Dr. Abhishek Manu Singhvi, himself has been and continues to be amicus curiae on a number of leading environmental cases. The fourth aspect I want to talk about is some of the landmark environmental cases, and I won't dwell at length. So for the benefit of the translator, case 1, Rural Litigation and Entitlement Kendra versus State of Uttar Pradesh, 1985. This was a case where limestone mining in the Mussoorie Hills damaged the ecology and public health. The outcome, Supreme Court ordered closure of the mines. What did it? It contributed to something important, which is the recognition of ecological preservation under Article 21 of the Constitution. Case number 2, MC Mehta versus Union of India, the Ganga pollution case, 1988. The facts of the case are industrial effluents were polluting the river Ganga. Outcome, closure of several polluting tanneries, mandatory effluent treatment was ordered. And of course, the contribution led to the right to clean water interpreted in the expansion of Article 21. I will not go into other cases decided by the courts, but there are an expansion of cases, including several MC Mehta cases, also the Indian Council for Enviro-Legal Action in 96, Vellore Citizen Forum in 96, T.N. Godavarman case in 1995, and many more, I will skip them. Another remarkable development in the evolution of the jurisprudence relating to eco-constitutionalism is the establishment of the role of the National Green Tribunal, what we call in India the NGT. The National Green Tribunal was established as a part of the NGT Act in 2020. The National Green Tribunal is a quasi-judicial body dedicated to environmental disputes. The key features of this institution are: it has special jurisdiction over environmental laws. It composed of judges and domain experts, something quite unique. It empowers restoration, penalties, and compensation. Its contributions have been quite stellar. Ordered closure of illegal mining in Goa and Meghalaya, banned diesel vehicles, which are more than 10 years in Delhi, protected Yamuna floodplains from construction, and operationalized polluter pays and precautionary principle in practice, which has been continuing. The National Green Tribunal continues the work of the Supreme Court by bringing technical expertise and faster redressal for environmental issues. The role of civil society. India's environmental jurisprudence owes its richness to civil society. MC Mehta, a lawyer activist, pioneered green litigation. Movements like Chipko, Narmada Bachao, Silent Valley, and Save RA galvanized a deep sense of national consciousness. Non-governmental organizations filed public investigations, conducted research, monitored compliance, and educated the public. Civil society transformed constitutional litigation into environmental democracy. Lastly, let's talk a bit about the challenges and the way ahead. There are significant challenges in what we are trying to do in the context of environmental constitutionalism. There is a strong dilution of some of the environmental regulations through the EAA notification as late as 2020. Climate change and biodiversity loss and environmental displacement have not acquired the kind of political space and public discourse in the wider context of India's political and social engagement. Regulatory bodies are facing political pressure and underfunding as well. What's the way forward? Mainstream environmental legal education needs to become institutionalized. We need to strengthen judicial institutions such as the National Green Tribunal. We need to incorporate climate justice, environmental personhood, and rights of nature into constitutional interpretation. We need to foster intergenerational equity and community-led conservation. In conclusion, I would like to say a bit about a tryst with environmental justice. At the stroke of the midnight in 1947, India awoke to freedom. In the 21st century, India must awaken to environmental justice. Through our courts, constitution, and citizens, we have crafted one of the world's most progressive environmental legal tradition. But this is not a finished story. It is a living commitment to the earth, to future generations, and to ourselves. Let us reaffirm that commitment. Let us uphold a constitution that breathes not just for people, but for the planet. Thank you very much.
Thank you very much for your powerful presentation. The Kiko Network will upload slide materials, although the slide materials were not shown on the screen during the presentation. I think participatory hybrid model, a national green tribunal. There are those things that are distinctive, and with regard to the role of a civil society, there was a powerful presentation. Now, I would like to invite Dr. Abhishek Shimbi, a member of the Parliament and senior advocate of Supreme Court of India, to talk about the SDGs and the policies and the legal actions.
I will go at a reasonable pace and not depart from the text, but I will have something to add which is not in the text, and it's going to be very simple so the translator will not be confused or misled. I'll try and keep to time, maybe even earlier. But let me start by saying thank you for having us here, to all the distinguished participants, academicians, administrators. It's a great pleasure and a privilege to speak under the auspices of your esteemed institution. And in a sense, you have a trilogy, a triad of themes, starting with Justice Mike Wilson and ending with me, with Raj in between, which covers the diversity of ecological and environmental themes, all very different, but ultimately they all deserve to be understood in a holistic synergy of that which makes environmental concepts, operational concepts, legal concepts, social concepts, policy concepts, political concepts. So Mike spoke to you about environmental litigation, and even though he gave examples from his home country, they are very live and very understandable from our country, indeed from most other countries. So they have paradigm relevance globally. Raj spoke to you about a different perspective, which fits in very easily into the sustainability. More Indian, more local, more focused on the jurisprudence of the apex court in India. I will speak, as I've been asked to, on an India focus, but in a policy perspective, how India has moved to achieving the pathways to the sustainable development goals. I'll apologize to maybe 4 persons who have heard this lecture yesterday, but all the others are new. And even those 4 persons will find a small part new. So friends, let me start by saying that it's important, indeed vital, for countries as close and yet as dissimilar as India and Japan to have such conversations as we are now having on sustainability, on our vision and understanding, our shared vision and understanding on the planetary future issue. I speak to you today from the heart of India, but also from the conscience of a generation of Indians who stand at the crossroads of progress and peril. This story of how India is trying to or has achieved several or walked successfully several miles on the pathways to achieving the SDGs is a story of transformation of how 1.4 odd billion people have to walk a tightrope between development and equity, a tightrope between ambition and responsibility, a tightrope between global commitments and local realities. It goes without saying, friends, that any system, and especially a justice system, which ignores the planet, is a system destined to fail both the people and posterity. Any failure on the climate crisis will not be just an environmental failure. It will be a failure of legal imagination and moral urgency. To sustain our planet, the law has to evolve from being a shield of the powerful to a sword of the just. India's engagement and moral consciousness, in fact, integrates completely with the concept of SDGs for the simple reason that it predates the SDGs. It predates the United Nations. Our ancient civilizations, and I'm sure the same is true of Japan, spoke of Vasudhaiva Kutumbakam, a concept of the world as a global family, a concept which worshipped rivers, trees, animals, nature as sacred, as co-inhabitants with the human race. In fact, to digress for 30 seconds, with apologies to the translator, I come from Jodhpur in Rajasthan, in the western part of India. And we have a community known as Bishnois. That's a community name. You can call it a caste name. Centuries ago, this community declared its fanatical adherence to nature. Not now, but in the 17th, 18th century, if people would come to cut trees anywhere near a Bishnoi community, the Bishnoi community, to a man and to women, would strap themselves onto the tree and dare the persons, the poachers, the commercial enterprises to either leave the forest alone or cut them along with the tree. This is a concept which has continued to modern times. This community has filed several actions which affect adversely forests and trees. So to continue, friends, and to not frighten or disturb the translator too much, we need to discuss the interdependence of law, justice, and sustainability. Because when we talk of climate instability, ecological degradation, social inequity, we cannot but have the intersection of law, justice, and policy. It is not an option, it is mandatory and indispensable. Law gives structure to our ambitions. Justice gives it legitimacy. And sustainability ensures its survival across generations. So this triad of law, justice, and sustainability, this trinity of law, justice, and sustainability, alone can enforce and ensure that policies become performative. Progress becomes concrete and development does not become exclusionary. So friends, let me quickly highlight more as point form, highlighting 6 powerful domains regarding sustainable development goals in which India has made real progress and is doing so every day as we talk. The first is energy and climate leadership. We have become a pioneer in clean energy. Our national solar mission targets 500 gigawatts of non-fuel capacity within 5 years from today. We have been a major mover and shaker of the International Solar Alliance. Our hydrogen mission, where India and Japan have special collaboration, makes us a global hub for the hydrogen economy. The second, water and sanitation for all. In particular, in a country which, though very rural and increasingly urban, is still also rural. 2 programs, Jal Jeevan Mission, which provides clean drinking water to over 200 million households. 200 million households in 5 years. Swachh Bharat Abhiyan, which has created over the last 10 years approximately 110 million toilets. These are not just figures. They are real operational fulfillments of SDG 3, which talks of health, of SDG 5, which talks of gender equity. Our women, rural women, had to defecate in the open. They had to go to the fields. And of water access, which is mentioned and elaborated in SDG 6. Ultimately, nature cannot have a lawyer till each one of us decide to become nature's lawyer. The third is our focus on sustainable agriculture, a natural focus for a country still predominantly focused on agriculture. So we have SDGs 2, 12, and 13 involved in enhancing productivity, but enhancing productivity with minimal ecological harm. And that is done by natural farming, by giving subsidies and encouragement to natural farming, soil health cards, minimizing harmful pesticides, and solar irrigation. The fourth is urban transformation, because that is as much important for SDGs as is rural. Our urban population alone will reach 600 million by 5 years from now, out of a total population of about 1.5 billion then. We have, among others, the Smart Cities Mission, redesigning 100 cities for sustainability, for resilience, and for digital governance. Cities which will minimize the carbon footprint. Cities which will minimize the wastage of energy. And we have the National Electric Mobility Mission, which is on a war footing, working on electric buses, charging stations, and also passenger electric vehicles. The fifth is health, air quality, and clean fuel access. The Ujjwala Yojana again provides clean cooking fuel to 100 million women. Just like rural India had the ungainly sight of women defecating in the open, rural India also had women using wood and highly polluting smoke-filled fuel in their homes. Clean fuel for cooking is a remarkable boon and a blessing for these women. Apart from being public health SDG, it is gender dignity SDG. National Clean Air Program targets 40% reduction in 2.5 PM or PM 2.5 levels within next year or 27. Now, I'm sure some of these targets will be exceeded, but we'll still be broadly on track, give or take a few months. And last but not the least, especially with India's demographic profile of approximately 1 billion people less than 35 years of age. Less than 35 years of age, 1 billion people. The focus on youth, innovation, and digital governance. There is a mission of creating, named after a former Prime Minister, for creating 10,000 laboratories focused on climate technology, grassroots innovation. And our digital public infrastructure is being repurposed, recalibrated more for sustainability monitoring and disaster preparedness. Friends, it's intersection of all these 5, 6 points with law, justice, and the rule of law and the role of law. We all have to accept that a legal system that ignores or pays less attention to the climate crisis is writing its own obituary. This is injustice for every unborn child. When the Supreme Court, which Raj has already talked about, has intervened less on law and more on grassroots result-oriented intervention. When air in Delhi becomes toxic, the Supreme Court orders industries to shift, to adopt clean technology, to stop. It even goes to the extent of setting down odd even numbers. Pollution without prosecution is another facet. It is ultimately permission without, that is, pollution without prosecution would be permission by another name. The forests cannot file petitions, but it's only the courts in India which suo motu hear their cry. Environmental justice also has to recognize that the maximum burdens are not borne by the most innocent people. They are not borne by the most marginalized, indigenous communities, low-income populations. Disproportionate impact of such good policies can make a good policy into a bad policy. There is a need for a redistribution of responsibility and resources in the context of climate justice through mechanisms like climate finance, loss and damage reparations, and technology transfers. Let me move towards the end by touching upon something which is normally not discussed in an SDG discussion, but has been held to be a vital part of SDG. And this is something which I did not speak on yesterday. That is about the SDG goals to end child labor. There again, the concept of no more tools in my tiny hands. We want books, we want toys. This ethic, this sentiment was given a great fillip in 1999 by the ILO Convention, the International Labour Organization Convention, and dealing with child labor, slavery, trafficking, bonded labor. It got a great fillip and a push. It was made into a very major SDG. And between 2000 and 2016, child labor dropped from 250 to 152 million. That's a 100 million drop. But yet, after this drastic improvement, the last few years have been unfortunately years of regression. For the first time in 20 years, these figures of child labor are increasing in Africa. During the same time, the world has become $10 trillion richer, but child labor is increasing. Policies which were already operational are seeing a backtrack. The US, over 30 states have introduced laws to weaken child labor protection. It has happened partly also in the EU. All of this needs, in terms of concrete policy, first, enforcement of laws. Second, child labor must be seen as a cross-cutting issue connected to education, health, and poverty, all of which are primary SDG goals. So, friends, in the couple of minutes left, let me end by saying that there are 5 concrete areas for partnership between your country and mine. Clean energy, technology, which includes green hydrogen, battery storage, and grid innovation. Sustainable urbanization, which includes smart city planning and waste management. Disaster risk reduction, which includes coastal management, seismic resilience, and flood protection. Academic and youth collaboration, which includes joint SDG research centers. And marine sustainability, which in particular is of great interest from Japan, which has blue economy projects. Friends, the SDG journey is not perfect, but it is powerful. It has to be seen as a common destiny, a shared responsibility. It is about ensuring dignity, opportunity, and justice, just as it is about attaining global targets. We have to see the 21st and indeed the 22nd century, both of us, Japan and India, not with anxiety, but with ambition. Not with competition, but with cooperation. Because we have to walk together for the sake of the planet and for the sake of our promises collectively to our people. Thank you very much.
リングさん、ありがとうございました。大変、今度はそのより広い政策などの視点からインドが取ってこられた政策についてお話しいただきました。法律、正義、それから
Thank you very much for talking about very broad policy. You talk about the policy, justice, and the triangle. Well, let us use the rest of the time to move on to the Q&A.
ぜひご議論にご参加ください。
Asaoka Sensei, could you also join us in the Q&A session? We have received some questions online. There's one question, some questions. Sorry, 2 questions. First question. Well, in the interest of time, Hishiyama-san raised a question. India is the 3rd largest CO2 emitter, inclusive of Japan. Many countries would like to achieve carbon neutrality in 2050. China 2060, India 2070. From 2050 to 2070, what is the reason why it's been delayed? What is at the background? Is there any move to expedite, bring forward of this objective? This is policy related emissions reduction measures. Therefore, Singui-san, could you first of all respond to this? And then Professor Kumar also, please let us hear your view as well. Singui-san first.
そうしましたら、ジャックマルさん、ぜひ。
So Professor Kumar, can you go first?
So, I mean, at the public policy level, there are lots of efforts that are being taken at both at the national level and the state level. But there is, of course, reluctance to convert this into legal and enforceable commitments. I think India is conscious of the fact that when we put certain commitments out into the framework, we will end up having legal obligations surrounding it. But I think we are going close to it. There will be a time, not to the near future, we will be able to sign up for those things as well. But in the interim, our goal should be to raise the level of awareness And one of the things that is being done as we speak is that it is slowly but steadily becoming part of a political priority through a lot of social action. And of course, we know that Indian courts are very powerful, and when they take cognizance, the the governments of the day end up making it more enforceable, and they use legal and institutional mechanism to fulfill that as well.
原さん、ありがとうございました。
Thank you very
それ
much.
では、一旦先に、もう
Well
一つ
then,
質問いただいておりますので、こちらは、
let us move on to the
ます。
next question.
5時53分にいただいている青木様からの最後の質問でございます。
And this is from
とんでもない
Aoki-san.
内容があちらこちらあり、ロシアや
I
北韓
think,
との落雷による被
for
害が
example,
相次いでいる
lightning
中、ありますが、
damage
昨
very
年、
frequent
こ
in
のよう
Russia
に
or,
局地
or
の落
North
雷電が観
Canada.
測され始めまし
And
た。
there was
この今の
it
子供
was
さんにとっ
the
て
lightning
将来
also
的な非
happened
常事態で
in
す。
the polar
海
area.
外各地の
It
人
is an
々はどの
emergency
ようなご支援をしてい
situation.
るとよく言えますかとい
I
うご質問
think,
なんで
do
す。
you
私
can you
は何
say
と申し
that
て
the
もよいので、
overseas
お
or
び恐れ
the
多いのですが、私
judiciaries
は今、
are playing a
皆
role,
さん
important
が
role
抱えている
for
問題で、
supporting the children under these
SDGs のところで
circumstances?
も特に
In the area of
強調され
SDGs,
て、
I think
子供を
you
守る
highlighted the
権利についてお
importance,
話しく
the
ださい
rights
まし
of
た。
children.
シングイさんに続けて、
So would you
答えを
please
伺いたいと思います。
talk about this topic to
Let me first talk about the
Dr.
fact that
Singhi?
there is you're talking about the global judicial collaboration that is happening with regard to building greater degree of both responsibility and sensitivity towards environmental issues. Justice Michael Wilson did speak a little bit about that global leadership, including the Global Judicial Academy and the work of it. IUCN also has a very strong focus on how to bring judges into it. One of the things that we can and should do in India, and now that I'm part of this panel, I want to initiate a much more stronger conversation surrounding both the National Judicial Academy and the State Judicial Academy, where we bring in environmental awareness and environmental consciousness to the judges, because these are all very important training and capacity building academies for judges. Judges from the lowest court to the highest court in India regularly both teach and are part of learning environments there. And it might be a good idea to make. Right now, I believe that it's a more an ad hoc aspect of it. Once in a while, in the training curriculum, issues like the environment are being introduced. But I think there is a case for substantively building a curriculum and and a framework for judicial decision-making processes related to environment, uh, and also to create a compendium of cases that have been held. Uh, we in India, many of us have come to know of the Juliana case largely through Justice Michael Wilson. I think that's not enough. Beyond, we need to move beyond anecdotal evidence and to develop a more substantive framework. We have been talking in terms of building a research center that focuses on environment and climate change, and especially in relation to the role of judiciary. I think there is a case for it, some sort of a global, environment and global judicial center or institute focusing on the best practices and the jurisprudence developed around the world, especially with regard to climate change. I think India has also gone through a transition with regard to where the environmental focus ought to be. And now the future is going to be based upon how judiciary becomes capable and more progressive with regard to addressing issues related to climate change.
大変力強いお答えをありがとうございました。それでは、シングイさん、お願いいたします。
Thank you. You asked me about child labor. I'm sorry I didn't have the earphone at that time. I deliberately brought in child labor because I have found this to be a subject conspicuous by its absence in most conversations on sustainable development goals. Seemingly, it doesn't fall under environment, but if sustainable development is about the larger holistic concept of environment, then child labor is a core component of it. It has been so held, taken, and treated right from 2000 when this global crusade started. And what I said about it was meant to highlight that most people don't realize that from remarkable progress in numbers, there is now creeping regression. I can understand that it is not improving that much, but how can we tolerate regression? How can the net number of people engaged in this horrendous system? Now remember, sustainable development is about development without adversely affecting, of course, environment, but adversely affecting health. Third, without adversely affecting women and children, or indeed other vulnerable sections. Now, just because commercially it is more desirable or seemingly lucrative, you cannot allow regression. Most significantly, 30 states, obviously under the impetus given by the philosophy which has led to the recent new government, has regressed on child protection laws because apparently it is not good enough for economic growth if you enforce them strictly. The EU has much lesser but still weakened those regulations. So it's my intention to flag it for you and say that the most important thing is to exercise utmost vigilance and disallow such creeping regression. Otherwise, all talk of SDGs will be empty if the human element, and especially the child element, is ignored.
はい、ありがとうございました。お時間が迫っておりますが、浅岡先生、一言お願いいたします。
Asaoka-san, please.
はい、大変哲学的なお話も。
Well, thank you very much for the philosophical thoughts to be shared. The last question, the Justice Wilson is sitting in front of me. With regard to climate litigations, what kind of a role attribution science will play in connection with the climate litigations? I hope that you will make a wrap-up comment, including responding to this question.
Okay. Aloha again. And that's a core issue that will decide how quickly we're going to be able to create transformational change with respect to the primary actors that are causing the climate emergency. The climate attribution is a relatively fancy word for just telling the truth. Let me give you an example of the kind of evidence that will be presented in many, many cases and has formed the basis of some evidence that traces the release of greenhouse gas emissions, then provides the conclusion that increasing greenhouse gas emissions increase the temperature of the earth, global warming. And finally, attribution science that shows that the companies involved, the energy companies, knew that this was a process, a damaging process to the atmosphere, and that they covered up that information and didn't tell the truth about it. Now, the extent to which that's going to be proved will be seen soon in Hawaii. We have what might be the most important climate case because the city and county of Honolulu and the state of Hawaii have sued the major oil countries of the world to prove through attribution science that they sold petroleum products and misrepresented that they would not create global warming. So thank you for asking that question, but this is a comparable level of scientific expertise to the expertise that was used in cigarette cases where experts testified that smoking cigarettes causes cancer. In this case, the science of climate change would be attributed to the companies that were releasing greenhouse gas emissions in the sense that they knew about the science. They knew the process, the damaging process that was being unleashed. Thank you.
Thank
you very much, Justice Wilson. My PC went down, so I could not read the question, the final questions. Sorry for my poor moderatorship, but time has come, so I would like to give back the microphone to Taura-san. Well, ladies and gentlemen, thank you very much for staying us until the very end of this webinar. When you exit the Zoom, you will be receiving the questionnaire, so we will appreciate if you can cooperate in filling in. Well, from US and from Indian experts, we could hear something very rare to be heard here in Japan. So I would like to once again thank today's speakers. And here in Japan, there are some climate litigations. This is a very important theme that we are working on. Therefore, inclusive of ourselves, we are looking forward to your continued support. Lastly, to all the audience, as well as to all the speakers, I would like to extend my heartfelt gratitude. Thank you very much. With this, the meeting is adjourned. Thank you.